It is very symbolic that, namely today in Vilnius, there is another international conference taking place in parallel under the auspices of Professor Dainius Žalimas, MEP, entitled Accountability for Crimes and Violations of Human Rights in Belarus, and we will be listening to his presentation as soon as he is able to come. And now I invite the Minister of Justice of the Republic of Lithuania, Ms. Evelina Dobrovolska, for a welcome address. Good morning, everyone. First of all, I would like to congratulate and thank the Chamber of Notaries, the Lithuanian Chamber of Notaries, for possibility to be here, to thank for the opportunity for our Ukrainian colleagues to be here, and to thank the Chamber of Notaries that the chamber was an example from the first days of war and provided assistance to Ukraine. It is a great honor for me to welcome you all to Vilnius today for this important conference, a conference which I hope will be a new milestone on the road to effective assistance to Ukraine, helping to further strengthen our support to Ukraine. In today's world, where the threats of populism and authoritarianism are on the rise, adherence to the rule of law is an essential condition. Safeguarding democratic principles to ensure that the law takes precedence over the interests of individuals and groups, prevent abuse of power by public authorities and ensure accountability of those responsible for decision-making, and guarantee that citizens' rights and freedoms are respected and protected. The rule of law is a fundamental value of the European Union, uniting countries with different national identities, traditions, and legal systems. One of the essential pillars of the rule of law, alongside independent courts, other legal professions, and active civil society and free media, is the Notariat. The Notariat ensures the legality and stability of legal relations and contributes to public confidence in the state's legal system. Therefore, the independence and impartiality of notaries truly ensure that the principle of rule of law is actually implemented and that the legitimate interests of every citizen are reliably protected. Ukraine, which is today fighting for its independence and democratic values, shows by its example the importance of strengthening the rule of law, even in the most difficult circumstances. Our goal certainly is to support Ukraine. For our assistance to Ukraine to be effective and efficient, we need to have a very clear understanding of what our partners need most today. This conference is a special opportunity to bring together experts, politicians, legal scholars, and practitioners who have invaluable experience and knowledge. So I invite you to share your insights and ideas to help strengthen legal certainty and the institution of Notariat in Ukraine and Lithuania. I hope that Vilnius will become a platform to bring together all the necessary assistance to Ukraine and to provide timely support to our partners. Finally, I would like to address our Ukrainian colleagues. Together, we will overcome all challenges on the road to strong justice and prosperity for your country. Glory to Ukraine. When we started organizing this conference several months ago, we cooperated closely with the Lithuanian and Ukrainian Ministries of Justice. Important reforms took place in Ukraine, and Olga Stefanishyna was appointed as the Minister of Justice. Because the management is being formed in Ukraine, the first deputy to the Minister of Justice of Ukraine will address the audience, Evgeny Horovets. Ponia Mariaus Tračkaitė, ponia Evelina Dobrovolska, Mr. Stračkaitis, Ms. Dobrovolska, first of all, I would like to thank you for organizing this high-level event. And I would like to thank for the support that the EU and Lithuania is providing to Ukraine. The large-scale invasion has been taking place for 2 years, and our critical civil infrastructure is being bombed. Because of that, a number of notarial bureaus have been destroyed or they had to move. Nearly all notaries have to overcome the problems related to regular airstrikes and shortages in electricity. The good thing is that the community of Ukrainian notaries demonstrate their determination during these hard times and serve the public. I would like to thank the Ukrainian notaries for their braveness, professionalism, and courage. And I wish Lithuanian and European notaries to be in our shoes, not to be in our shoes. Notaries work day and night, and they make every effort for them not to take our place. The reform of the Notariat is of great importance, and the digitalization of the activities of notaries. I'm convinced that the participants of today's event will discuss topical issues, will share their knowledge, and the Ukraine will learn from these exchanges. I would like to extend my gratitude once again to the colleagues from Lithuania and Europe, which help us to reform our legal system, including the notariat system. Glory to Ukraine. Thank you for connecting, and I invite you to continue observing our conference via Zoom. Now we will start the working part of the conference. Today, we are joined by a video message from Anna Jarosz-Fryz, Director of the Ukraine Unit of the European Commission's Directorate General for Neighborhood Policy and Enlargement Negotiations.
Of the Council of the EU Notariats, dear Minister of Justice of the Republic of Lithuania, members of the European Parliament, esteemed notaries, ladies and gentlemen. It is a great pleasure to address you at today's conference. I sincerely apologize that I could not come to Vilnius this time, but I hope there will be other occasions in the future. First of all, let me express my admiration for the resilience of the Ukrainian notaries who continue providing important notary services despite all the challenges caused by the ongoing Russian aggression. I also warmly welcome the EU notaries for your strong support to your Ukrainian colleagues from the very first days of Russia's full-scale invasion, and for embracing them into the EU notary community. I am confident that your partnership will further develop as Ukraine advances on its EU path. EU accession offers a unique opportunity for a profound transformation of Ukraine. It is a geostrategic investment in our shared peace, stability, and prosperity. After the historic decision of the EU leaders to start the EU accession negotiations with Ukraine, the Commission is now taking the process forward. We are starting the screening of Ukraine's compliance with EU law and are expanding our pre-accession technical assistance to Ukraine. The rule of law, as one of the fundamentals, will assume a central role in the accession negotiations. Ukraine has made substantial progress in this area since the Revolution of Dignity, and even the Russian aggression has not stopped the reform efforts. Good progress was also achieved in the notary system, The Ukrainian Notariat has gradually assumed new responsibilities and gained increasing public trust. Yet, despite these positive trends, much still remains to be done in the area of rule of law. But I am confident that with our joint efforts, hard work and partnership like the one built among the notaries, Ukraine will overcome the Russian aggression and will emerge as a strong, prosperous member of the EU family, founded on the values of the rule of law. I wish you all a very fruitful conference and send you my warmest greetings from Brussels.
Thank you, Director. Manfred Liman, who has been working in this directorate for the European Commission for a number of years, helped us to keep in touch with Anna Jarosz-Fries. And he was going to come to Vilnius himself, but unfortunately, the European agenda is very tight and he was unable to do that. So let's continue with our working part of the conference, and I invite the President of the Supreme Court of Lithuania, Associated Professor Dr. Danguolė Bublienė, to present a paper on entrusting judicial functions to notaries, further possibilities and perspectives.
Gerbiami konferencijos dalyviai.
Dear participants of the conference, thank you very much, first of all, to the Chamber of Notaries for this honor to speak to you today. I truly believe that this conference is not just a place to exchange information. It is also incredibly important to create that common sense of unity. It's important to be together in this day and age. It's important to be together and it's important to work together. So let's start with the working part of the conference. So truly, strengthening the rule of law and notariats, insights from the European Union member states and Ukraine is the theme of today's conference, and I believe it was chosen not by chance. Usually, when it comes to the rule of law, it is the courts that are the most often referred to as the guardians of this principle. However, it is clear that this system cannot be understood too narrowly. First and foremost, everyone who applies the law, and therefore every legal corporation, is the guardian of this principle. This is all the more true for notaries, who, to quote an EC study, are one of the most important pillars of the judicial system. It is clear that Latin notaries contribute to the administration of justice in its preventive stage by ensuring the legality of transactions and performing other related functions. Notaries are the guardians of legal certainty and, more generally, are a protective mechanism for public life. Notaries play an important preventive role in avoiding litigation. They reduce the workload and costs of courts by exercising the competence of non-adversarial procedures. The role of the notary as a preventive or non-contentious judge has long been debated both in the EU and in Lithuania. The transfer of certain court functions to notaries has also been discussed for quite some time. However, in order to further discuss what and how notaries can be entrusted with certain functions, it is necessary to agree on definitions. And I would like to draw your attention to the terminology we use in Lithuania in both political and strategic documents, in public information, and in discussions among ourselves. One can find statements such as functions that are not inherent to courts, the transfer of these functions to notaries or judicial officers. So these are extracts from documents where these terms are used. The State Audit Office goes further in its 2020 study by stating, the Audit Office survey of district courts shows that courts themselves have different perceptions of what functions are outside the scope of courts. 6 out of 12 courts cite as a function outside the scope of the courts the handling of divorce by mutual consent. Out of 12 courts cite that granting the permission by a court for the disposal of immovable property, which is a family property when there are minor children in the family, is a function not inherent to courts. In surveys, some courts expressed the opinion that courts should not deal with cases under the summary procedure. I have the impression that we ourselves do not understand what the judicial function is. Isn't divorce by common consent, the other examples given, a function of the courts? On the other hand, is that how the question should be posed? Or would it be more accurate to ask, would not the transfer of this function to notaries contribute to a more efficient administration of justice? The old wisdom says, ask as you ask, so shall the answer be. So concepts are certainly important. The very use of the term abolition of non-judicial functions leads to confusion and misunderstanding as to what is a judicial function and what is the administration of justice. On the other hand, this uncertainty naturally arises from the case law of the CJEU itself, which I will discuss shortly. Already last year, Professor Vytautas Nekrošius, in his presentation at the 30th anniversary conference of the Notariat, also pointed out the flawed nature of this concept, referring to a special court where there are no disputes, but where judges also perform functions. The EC Commission on the Efficiency of Justice, in its 2023 study, pointed out that the transfer of non-contentious functions is being carried out in order to reduce the workload of courts and to contribute to the efficiency of justice for individuals. Thus, it is not giving up functions that are not inherent to courts, but achieving efficiency of justice we're talking about. It is also important that the term efficiency is used in this study, not effectiveness. And that is effectiveness that is not associated with efficiency and therefore economic efficiency. On the other hand, it is also clear that when it comes to state functions, it is necessary to agree on which state functions, public or non-public, and to which entities should be transferred, and which model is the best for a particular state. The fact that the state delegates war on another function to the courts, or conversely takes it away from them, does not mean that this function becomes inherent or outside the scope of courts. For example, in Germany, the courts carry out the function of registering legal persons, whereas here in Lithuania, this function is carried out by a dedicated center. But this does not make it judicial or not judicial. It is clearly a matter of agreement or a choice for each country. Having agreed on the concept, let us ask ourselves the question, is there any reason to believe that notaries can be entrusted with more judicial functions in order to make the administration of justice more efficient? Let's try to answer this question by analyzing three levels: status as notary, functions of a notary, general assumptions. So status. What is it? Who is a notary? Freelance professor? A person exercising public authority? Subject of an economic activity? A person exercising judicial functions? That is, a court. According to Article 2 of the law of Notariat, a notary is a person authorized by the state to perform functions established by the law on notariat, ensuring that civil legal relations are free from unlawful transaction and documents. So the normative definition does not give a clear answer to this action. So, is a notary a representative of free profession? Notary. A number of sources confirm the view that profession of notaries is a free one. Notaries themselves present themselves as a free profession. The CJEU, in its judgment of January 18, 2024, summarizes. The Court of Justice has already ruled that since they are engaged in a liberal profession whose main activity consists in the provision of several separate services for remuneration, notaries in effect are engaged in an economic activity. The court made this generalization in the competition case, although it relied on the findings in the context of freedom to provide services. So in the recently published book, The Responsibility of Notaries, the authors of the book said, and the authors in the book argue that the question whether the profession of notaries is a free profession is not so simple after all. The court, in its judgments, understands and recognizes that notaries perform public functions, but according to court, this is not sufficient to judge their activity as a public function. The Court of Justice said that notaries work in competitive conditions, which is not a very specific. If we believe that the sanctioning of divorce is not a state function, it would mean that the marriage should not registered in registers, or even termination its dissolution would not need to be registered. But the opposite is true. This debate is certainly worthy of a separate academic study involving both private and public law scholars. The Court of Justice made another judgment in the same case of January 18th, 2024, case C 128. In this respect, the Court of Justice has already ruled in principle that notarial activities which authenticate acts expressing unilateral commitments or agreements freely entered into by the parties cannot be directly and specifically attributed to the exercise of public authority. For example, the conclusion of mortgages, the conclusion of pledges. Of particular note is a recent case on freedom to provide services. The Court of Justice analyzed the activities of notaries in the field of issuing court orders. The Court of Justice considered the features of this practice, namely the payment orders are limited to undisputed pecuniary claims, which are already overdue, and that the payment order issued by a notary becomes binding only if the debtor does not appeal against it, to be the competence of the notary, which is based solely on the common will of the debtor and the creditor, and does not alter the court's prerogative in the absence of an agreement between them as to the existence of a debt. The Court of Justice also assessed the notary's competence in the field of declaring a European order for payment enforceable if no objection has been lodged within the prescribed time limit. The Court of Justice regarded the order of enforcement as an authorization to start the recovery of debt, which, in the absence of a corresponding complaint, constitutes the subject matter of the order for payment made binding. Although the notary's endorsement of the order for payment as enforceable on the order for payment, which has become binding, makes it enforceable, this is also based on the fact that the debtor has not contested the debt to be recovered. The fact that the order for payment has thus become enforceable did not persuade the Court of Justice to conclude that the notary has powers involving direct and specific participation in the exercise of public authority. The court considered that the issuing of the court for payment to be ancillary and preparatory to the activities of the court. I confess I'm a little puzzled by these arguments, because it would follow that in relation to the injunction, the courts are not courts either, since there is no reason even to regard the issuing of an injunction as a public authority function. Is a notary a subject of economic activity? The answer today is known very well, and it was discussed among notaries this year as well. We now have a ruling from Court of Justice. Article 101 of TFEU must be interpreted as meaning that notaries established in a member state are to be regarded as undertakings within the meaning of that provision, when, in certain cases, they approve mortgage pledge transactions, execute executive entries, perform notarial acts, draft transactions, provide consultations and technical services, and approve exchange contracts, insofar as those activities do not relate to the exercise of public authority. This interpretation is hardly surprising, as the Court of Justice has consistently held in previous judgments that the functions performed by notaries are not functions performed by a public authority, as I have already mentioned, including The court emphasizes that notaries operate under competitive conditions, even if these conditions are limited. So if notaries are not a public authority, they're naturally an economic operator. On the other hand, it is quite clear that the Court of Justice does not deny the public interest protection function of notaries. Neither the previous nor the most recent decision by the Court of Justice, I dare say, threatens the notarial profession, the functions performed by notaries, and does not call into question the fact that notaries could be entrusted with certain judicial functions. Do the notaries perform judicial or court functions? At the beginning of this presentation, I mentioned that the notary is often called a preventive, preemptive, or non-contentious judge. However, these terms do not directly define the status of the notary as a performer of judicial functions. Whether the activities carried out by a notary can be considered as judicial functions is a question that requires a separate analysis. The answer, however, may be very simple. If a notary is not a public authority, he is obviously not a court. However, again, a separate analysis is needed. A notary is a legal professional. Like a judge, he is subject to high qualification and selection requirements. Notaries, like courts, act on the basis of the general principles of independence, impartiality, and objectivity. The principle of independence, including financial independence, of a notary is directly enshrined in the notarial law. As early as in 2011, the Supreme Court of Lithuania, when examining the notary's refusal to perform notarial acts, stated that the concept of the notary's function presupposes the conclusion that the notary does not examine disputes of person, does not establish disputable circumstances, and in the case if there are any doubts or disagreement regarding the rights of persons or legal facts, he is obliged to refuse to verify or authenticate certain rights and facts. A notary may certify certain rights or facts only if there are no doubts as to their content or legality. Court of Justice, adopting a decision on the appeal of the Supreme Court of Lithuania, took essentially the same position and did not recognize the functions performed by the Lithuanian notaries as judicial, even within the framework of the succession regulation, which defines the court more broadly than the Brussels regulation. The Court of Justice considers judicial functions to be only those where the authority is empowered to deal with a dispute of law. The assertion of undisputed subjective rights does not constitute a dispute of law, according to the Court of Justice, although the Court of Justice left the honorable right to the Lithuanian court to make its own assessment. Its own assessment of the Court of Justice was so eloquent and obvious that the National Court had no alternative but to repeat the conclusions of the CJEU's judgment. So the answer today is that the functions performed by notaries in the field of succession are not judicial functions. Moreover, the CJEU has stressed speaking on the concept of a court and in cases concerning the independence of the judiciary, that an institution satisfies the concept of a court if the right of the parties to be heard is ensured, regardless of the form, whether oral or written. In the absence of this element, an institution cannot be considered to be a court. It is important to bear this aspect in mind when considering further the question of delegation of judicial functions to notaries. In summary, even though notary's profession is one of the oldest professions in the world, the debate on the nature of the legal status of notaries is still alive. Notaries are a free profession, but in a limited sense, and therefore not as free as other free professions. Notaries are not public authorities, but perform a public interest function. Notaries are economic operators, albeit under limited competitive conditions, but also perform a public interest functions. Notaries are referred to as preventive judges, and their preventive role in the administration of justice is recognized, but they are not judges and do not perform judicial functions. Sound very equilibristic. Professor Michelenos pointed out in his speech at the Notariat 30th anniversary contract, the mere fact that 30 years after the reform of the Notariat in Lithuania, such a question is being formulated is a matter of some concern. I agree with the professor. In today's society, the evolving, changing, and increasingly complex nature of social relations means that many legal issues have to be reconsidered, and they take on a different meaning. Sometimes it is difficult to fit them into a single legal institute. One thing, however, is clear. Notaries perform functions of public interest. Certain activities performed by a notary may be recognized as economic activities, as activities performed by certain public authorities. It all depends on what and how we entrust functions to the notary. I therefore believe that this discussion and the mixed revelations about the status of notaries do not preclude further discussions of what and how judicial functions could be transferred to notaries. The functions of Lithuanian notaries have already been considerably expanded compared to the traditional functions of the Latin notariat. Notaries have competences in the fields of legal persons, mortgages, execution of executive records, divorce. Moreover, the notary's competences are extended to mediation services. Most recent reforms to extend notarial functions in Lithuania are noteworthy, and that is in the area of mortgages and divorce. More than 12 years have passed since the abolition of mortgage judges and the transfer of mortgage functions to notaries as of July 1st, 2012. It is also more than a year since notaries were entrusted with certain family law functions. There does not seem to be major systemic problems in the first area, or at least the case law does not indicate that. Several cases have reached the Supreme Court of Lithuania concerning notarial entries. In 2014, and later in 2016, ruling, the Supreme Court of Lithuania clarified that the notary does not check. They do not assess the conformity of the creditor's data and is not liable for them. The notary performs a formal assessment of the data provided in the creditor's application and does not resolve disputes between the mortgage parties. The notary performs only a limited legal examination, a formal verification of data, and does not resolve disputes between the parties. The several Supreme Court cases indicate that not all problematic aspects have not been thought through when drafting the reform, namely the aspects related to the application of statute of limitations when a creditor applies to a notary for the execution of a notarial deed. Several cases were dealt with the issue of the application of the prescription period, how it should be calculated, who has the right to decide on its application, non-application. The Supreme Court of Lithuania has clarified that on the basis of Article 1.130 of the Civil Code, the prescription period is also interrupted by a person's application to the notary public in accordance with the procedure established by law for the issuance of an enforceable document. In this case, the limitation period shall be deemed to be interrupted from the moment of submission of a person's written request for the issuance of an enforceable document to the notary. In another case, the Supreme Court has clarified that where a legal regulation provides for the creditor's right to recover monetary obligations from the debtors out of court in the case at hand by means of a notarial enforcement record, the debtor, having received the creditor's demand to pay the debt in good faith or the notarial enforcement record for the recovery of debt, has the right to protect their violated rights by bringing an independent action against the creditor for the application of limitation periods. Divorce is probably, it's too early to draw any conclusions. In fact, the National Audit Office 2020 report predicted that according to the auditor's estimate, if the decision to transfer to other institutions at least two functions that are not inherent to courts, divorce, for example, by mutual consent, and the issuance of court permits for the conclusion of transactions involving real estate, that is family property, if the spouses or applicants have minor children, were to be approved, the number of civil cases in the courts would be reduced about 13%. That is 20,000 cases. Today's statistics provided by our National Judicial Administration do not confirm these forecasts. We need to calculate statistics on a case-by-case basis, but based on the statistic information we have on hand, we observe a decrease of around 4.5% in the number of cases in courts. So to draw solid, reliable conclusions, it's necessary to carry out qualitative analysis, not just quantitative one. And first of all, notaries themselves should tell us how they manage to perform these functions, especially in the light of the skepticism expressed a year ago at the 30th anniversary conference of the Notariat about the transfer of these functions and the perception of various threats. It is too early to draw any conclusions from the case law, including an assessment of how many cases have been reduced in courts as a result of the transfer of certain functions to notaries. The latter reform will undoubtedly have to be the subject of an ex post analysis, which should be the responsibility of the Ministry of Justice. It is precisely the successes and failures of the reform, as well as the lesson learned from them, that will be able to help to decide on the further development of the functions of notaries with a view to achieving a common goal for the entire justice system, that is, better administration of the justice system and better protection of the rights of individuals. Briefly about general assumptions. Trust in notaries, I have to say, is high. We've discussed this on a number of occasions, on a number of conferences. The network of notaries is sufficiently developed, and I have a very clear image on the slide where you can see the locations of notary offices in Lithuania. So notaries have offices in many places in Lithuania, meaning they are sufficiently close to the general public. The network of notaries can be developed much more efficiently than the network of courts. The environment of notary's office is more friendly than that of a court. The communication with the notary does not require any special process. The advisory function notaries carry out allows for a more direct contact to a person's problem. The function of notary certification of transactions makes it necessary to be close to everyday practice and decisions. A notary is not just a lawyer. Let me recall the widely quoted words of the German Minister of Justice, Dr. Mark Busch, at the German Notaries Congress. A notary is both a priest and a doctor. A notary takes a broader view. A notary listens, understands, advises, not only in legal matters. Thus, a notary is a priori in many ways closer to the general public. I would also mention that Lithuania is still one of the leading countries in terms of the number of civil litigation cases. According to the EU Justice Scoreboard of 2024, we are in the fourth place. On the other hand, we are in 14th place in terms of the total number of civil and administrative cases. And that could be due to the division of competences between notaries and courts. So the general presumptions are very favorable in terms of discussing the further transfer of functions to the notaries. But it's about time to talk about trends. One of the studies done by the European Commission shows that in order to simplify and to relieve the burden of courts and public administration, certain functions should be transferred to notaries. The development is reflected not only in the regulation of succession, where many EU member states have entrusted notaries with the competence to issue the European certificate of succession, but also in the competence of notaries to divorce by mutual consent and in the role of the notaries as agents of the court. So I believe this is the future that we are going to see. But a trend is just a trend, and all trends are subject to change. But this is one of the prerequisites and very serious one for considering further options for more efficient administration of justice. Today, this trend clearly shows that the search for an efficient administration of justice is not being pursued in one country alone. That pursuit is happening in more than one country. Solutions are being taken in the same direction, namely entrusting notaries with a broader range of justice administration functions. Thus, qualitative research on the solutions already taken to transfer judicial functions to notaries and their impact on public confidence in the legal system could be used to consider further steps. For example, to start discussing the extension of the functions of notaries in relation to uncontested claims, or even to extend their functions in the area of succession law, even if the situation is not obvious and there is a dispute over law. So the legal presumptions are there. The trends are positive. It's up to us to decide. Just a small matter. Thank you.
Thank you, Ms. President. I hope that the presentation by the President of the Supreme Court has given colleagues from Ukraine a lot of ideas on how and what could be improved and what path the Ukrainian Notariat should follow. It gave food for thought for us, for me personally, and I can say that the new practice, a new regulation mentioned by the Ms. President, when the cases of marriage dissolution with no underage children and the transfer of these and the implementation of this reform and continuation of this reform is important because the role of the notary can be extended where there are minors, but there are no disputes. But these are the issues that will be discussed in the future. We will discuss them in conferences, and later on it will lead to legislation. Now I'm going back to our agenda, and I would like to invite Ms. Gabija Gibaitė-Daugirdę, Vice Minister of the Ministry of Justice of Lithuania, to deliver a presentation, Special Tribunal for the Crime of Aggression against Ukraine as a Fundamental Reflection of the Rule of Law.
Good morning, and first I would like to share my warmest welcome to all of you coming here to Vilnius, and especially, of course, for our Ukrainian colleagues making that hard way to come here. And secondly, I would like to express my gratitude for the Lithuanian Chamber of Notaries for continuing firm support to Ukraine and for inviting me today to address all of you on the role of the rule of law in pursuing justice for Ukraine. The notion at the heart of the rule of law is that nobody is above the law or behind political power. And last week in Vilnius, ministers of justice of the Council of Europe met in the conference, focus of which was accountability for international crimes being committed in and against Ukraine. One of the sessions was devoted to the legal and political issues surrounding the future special tribunal for the crime of aggression against Ukraine. Ministers adopted a declaration reaffirming the necessity of establishing an effective special tribunal for the crime of aggression against Ukraine capable of delivering justice by holding accountable those who bear the greatest responsibility. Declaration also mentioned that the establishment of a special tribunal should respect international law and enjoy broad cross-regional support to guarantee its legitimacy. And this wording reflects on two aspects of the rule of law that I am planning to address in my remarks today. First, necessity to prosecute Putin and his entourage as having the greatest responsibility for aggression against Ukraine. And second, that tribunal itself must also be based on the rule of law, respect international law, and I will explain in what way this should be reflected in the establishment. And today I start by reminding all of you the fundamental lesson of Nuremberg Tribunal. That is that concrete persons and not abstract entities like states are responsible for waging wars. And the crime against peace, as it was known at that time, which we now call the crime of aggression, is the supreme crime and the source of evil, because this crime is followed by other atrocity crimes, such as widespread and systematic war crimes. Wherefore, individual criminal responsibility for the crime of aggression must be as central as possible in the justice framework for Ukraine. And what we still witness today is that for some states and politicians, it is more comfortable to deal with consequences of the crime of aggression than to deal with the main cause, because dealing with the main cause, that is the crime of aggression, entails difficult political judgments that states must do. But only if international criminal responsibility for the root cause and not only for the consequences is ensured, the credibility of the fundamental prohibition of the use of force can be restored. And this rule is the cornerstone of international legal order. Already a long time ago, Hans Kelsen emphasized the centrality of the prohibition of the use of force not only to international peace, but also to the very idea of international law. That is why there must be an international cross-regionally supported trial for the crime of aggression in order credibility of international law is being restored in its entirety. The other lesson of the Nuremberg rests on the need to emphatically reject the paradox that legal responsibility is the least where power is the greatest. Where powerful national leaders, leaders of the permanent members of the UN Security Council, offend fundamental international legal rules, they can be pushed to the margins of political power only through the work of effective international justice. Because rule of law-based order is not rule of power-based order. Nuremberg opened a new era in that it established and enforced responsibility of those having the greatest power and set irrevocable precedent for the present. The Special Tribunal for the crime of aggression against Ukraine provides the world with the chance to also open the new era, an era in which the golden seat in the UN Security Council does not entail impunity, even in the case of the most severe international criminal responsibility. The crime of aggression against Ukraine is a crime against the entire international community, and that is why the international community as a whole must decide on how it holds heads of aggressor state accountable for acts that directly affect that community. The definition of a crime of aggression and its inclusion in the Rome Statute of the International Criminal Court was a universal exercise in which all permanent members of the UN Security Council took an active part. Russian delegates expressly accepted the definition. Hence, the law is in place and it demands for the prosecution of the leaders of the aggressor state. At the time of Nuremberg, there was no Rome Statute, no International Criminal Court, and no other important developments in the area of human rights. And yet, Nuremberg already denied the applicability of immunities. Applicability of personal immunities before national courts is based on the concern that otherwise national authorities might abuse prosecutions for political reasons in order to impede or limit a foreign state's ability to perform international relations. But this danger does not arise with properly devised international courts and tribunals, as they are independent of states and function according to strict rules of impartiality. Legal and political discussions on the possibility for the future tribunal to lift personal immunities of Troika continue. because there are states who believe that this is still not possible to prosecute leaders of a state for the leadership crime of aggression under international law as it stands today. Robert Jackson, the chief prosecutor of the United States at Nuremberg, said that unless we are prepared to abandon every principle of growth for international law, we cannot deny that our own day has its right to institute customs and conclude agreements that will themselves become sources of the newer and strengthened international law. Indeed, international law is more than a set of immutable principles, following the words of Justice Jackson. Creation of a special tribunal concerns rules of international law, whose interpretation has yet to fully consolidate. Yet these rules are already capable today of finding an unprecedented but necessary solution to adjudicate the supreme brutal crime of aggression against Ukraine. So wherefore, it is not so much a legal, but ultimately a political challenge to agree that also a head of a permanent member of the UN Security Council must face responsibility now. That is, at the moment in time when the devastating breach of international peace and security has been committed and continues to be committed today. An aggression trial is vitally important for the historical truth established by law. But in order this historical truth is not undermined in the future, tribunal must be established according to the rule of law. And now I turn to the second aspect of the rule of law, explaining how this tribunal should respect international law to be legitimate. The question whether or not to include the crime of aggression and how to define it was one of the central disputes at the diplomatic conference that led to the adoption of the Rome Statute of the International Criminal Court. There was no consensus on the definition, and as part of a final compromise, the crime of aggression was included in the list of crimes under the jurisdiction of the court, but the definition and the conditions for the exercise of jurisdiction were left for the first review conference. And in the first review conference in 2010, definition of the crime of aggression was agreed, as well as special provisions on the exercise of jurisdiction over the crime of aggression, and now precluding the court to exercise jurisdiction over the crime of aggression against Ukraine. The definition of a crime of aggression in the Rome Statute, first, following the Nuremberg precedent, has a leadership clause and covers only political or military leaders in a position effectively to exercise control over or to direct the political or military action of a state. And second, the crime covers only manifest violations of the UN Charter. These important developments can be regarded as the most important evidence of international criminal law being a peace project, because finally it enabled to enforce the fundamental norm in the UN Charter, that is prohibition on the use of force, by invoking individual criminal responsibility for leaders of aggressor states. Definition of a crime of aggression in international law is there, so it is of crucial importance that tribunal operates on this definition, does not try to create its own definition or take the definition from Ukrainian domestic criminal code and undermine what has already been agreed by the international community. And then for the legality and legitimacy of the tribunal, procedure of establishment being in compliance with international law is crucial. Different models are still being discussed, and I would say that different models, they represent different objectives that proponents of each of the models have. Main difference is that Ukraine, together with Lithuania, other Baltic states, and some other states, argue for the need of strong and effective precedent in the form of a fully fledged international criminal tribunal capable of lifting personal immunities of Troika. And other states want to diminish precedent value from purely self-protection perspective so that later the precedent set does not turn against them. Model of establishment is not technical issue as sometimes it may seem, because efficiency and deterrent effect of a tribunal depends solely on its establishment model. Each of the model has certain legality and legitimacy concerns, but immunities is the key issue surrounding all the models. And I will explain why. Because International Court of Justice in the arrest warrant case emphasized that Troika members, that is, President, Prime Minister, and Minister of Foreign Affairs, enjoy personal immunity before the domestic courts of any state as long as they hold the office. But personal immunities does not apply before international courts and tribunals following the same judgment. No features of being international were provided, but International Court of Justice mentioned both criminal tribunals established by the UN Security Council resolutions and International Criminal Court that was established by the multilateral treaty with cross-regional support. Wherefore, one can conclude that to be international, it is important that tribunal acts in the name of the international community and exercises its jurisdiction on behalf of international community. Wherefore, one can conclude that special tribunal established as Ukrainian internationalized domestic court without significant involvement from the international community could not be considered as exercising criminal jurisdiction on behalf of the international community, and personal immunities would remain applicable. Talking about modality of international tribunal and understanding that UN Security Council is paralyzed, UN General Assembly could recommend establishment of the tribunal and could request that the Secretary General conducts negotiations to conclude an agreement with Ukraine on behalf of the United Nations and establish special tribunal. In the history of international criminal justice, international criminal tribunals were established following UN Security Council resolutions. There is no time for me to go into details on the functions and mandate of the UN General Assembly to prove that this institution could be suitable for the task, but if special tribunal is established following General Assembly resolution, it would have the strongest claim to the status of being an international tribunal. Regional model and involvement of the Council of Europe is the latest development in relation to modalities of establishment being discussed, because Secretary General of the Council of Europe was authorized by member states to prepare documents that would be needed for the establishment of the tribunal. Council of Europe has shown leadership working toward justice for Ukraine, and its mandate does include defending the rule of law and human rights. But the question remains if regional solution can be considered as solution in the name of international community, and could Council of Europe be actually considered as acting on behalf of international community while establishing the tribunal that in due course lifts personal immunities of Troika. In my opinion, UN General Assembly role should not be underestimated for post facto authorization of the regional model, because resolution adopted after the establishment could also support the conclusion that regional tribunal is acting in the name of the international community. Possibility of establishment of the tribunal on the basis of multilateral agreement between willing states and Ukraine without the involvement of the international or regional organization raises more legitimacy concerns. There would always be the argument that such tribunal is simply an expression of specific group of states. And if these states are the ones that have been previously occupied by the Soviet Union, such tribunal would face impartiality and independence critics for implementing historical justice. Concluding on the question of how international community should also not forget that Nuremberg is an example how history and truth can be manipulated through the legal process if the legal process is not done in the right way. In 1945, the Soviet Union got away sitting on the other side of the bench. The lesson we must learn is that the legal arrangements that accommodated political preferences of that time at the price of compromising full legitimacy and full justice had devastating consequences for the peace in the future. Wherefore, today, with the establishment of the tribunal for the crime of aggression of Russia against Ukraine, international community has to make sure that no space is left for political manipulations, imperial ideology of Russia is being condemned, and no impunity illusions are again being created. Lithuania, from its history, perfectly knows how crucial time is in the administration of justice. Politicians change, evidences vanish, memories fade away, as well as promises of justice being made. Wherefore, while trying to answer the question, how and when tribunal for the crime of aggression against Ukraine will be established, I want to reiterate that first but very important procedural steps have already been made. International Center for the Prosecution of the Crime of Aggression against Ukraine is established and is fully operational. The main objective that the center has is to agree on the common prosecutorial strategy and facilitate case building for future trial of the crime of aggression against Ukraine. Also, to ensure that evidence of the crime of aggression against Ukraine that are being collected in different domestic jurisdictions are being preserved and verified under coherent procedural standards. As Prosecutor Jackson at Nuremberg said, for incredible events, we need credible evidence. Wherefore, focus on evidence today makes sure that justice, sooner or later, prevails. And I will conclude my remarks with the words of Kofi Annan. We have the means and the capacity to deal with all our problems, if only we can find the political will. Vilnius has courage and political will, and it is very clearly written on the Vilnius municipality building. Putin, The Hague is waiting for you. So enjoy your stay in Vilnius. Thank you once again for invitation, and I wish you fruitful discussions in the coming days. Slava Ukraini!
Ačiū, viceministrė.
Thank you, Vice Minister. Now I invite the Director of the Notariat Department of the Ministry of Justice of Ukraine, the Honorable Vera Bogdarenko, to present the report and presentation, a message from the Ministry of Justice of Ukraine to us on the development of Notariat in the crisis time.
Шановний пане Маріусе Страчкайтіс, шановні представники
Dear Marius Stračkaitis, President of the Council of Notaries of the European Union, I'm very happy that you've invited me to this important conference. It's really important for us, our country, and the whole of the EU. Today, I have the opportunity to speak about the development of the notariat through the prism of war. The notary in Ukraine plays a key role in the legal system of our country and is the institution to which the state has not only delegated most of the functions in the field of indisputable jurisdiction, but is gradually expanding the range of delegated powers. There are about 5,000 notaries covering all corners of our country. Today, a notary not only certifies rights and facts of legal significance, but is also a state registrar of rights to real estate and business, as well as a subject of primary financial monitoring. Then they also play a significant role in the system of combating money laundering. In addition, as I mentioned, we have around 6,000 notaries today. Notaries have also been empowered to record property damage and destruction caused by Russia's military aggression, as well as to implement a compensation mechanism for destroyed housing. War did not stop the work of public institutions, ministries, together with the notariat community.
We aim to protect the rights of natural persons, their property. Notariats find ways to protect the rights and properties of people and to ensure that our registries work uninterrupted. The war has been going on for the past 3 years, and we cannot stand in place. Our goal is full-fledged membership in the EU, for which our country is making extraordinary efforts, and notaries are no exception. The main goal of the Notariat reform is to introduce electronic notaries, and much has already been done to this end. Thus, in 2021, we launched a pilot project to gradually introduce the unified state electronic notariate system in the form of a scalable electronic platform that will integrate and will integrally transfer all notarial acts to the electronic environment, automate the acts, ensures the efficiency of notarial acts, will optimize the administrative burden for notaries and clients, and will provide quick access to the notarial acts already performed. Since 2021 to 2023, our work was being carried out to create the e-notary system and its individual components. So the software for the inheritance register, for the unified register of powers of attorney, the unified register of special forms of notarial documents was updated, and the functioning of these separate registries as components to the e-notary system was transferred. The register received a new user-friendly interface. Business processes were restructured for maximum user convenience. An electronic notary workstation was created to provide users with access to the components of the e-notary system in order to search for and enter information, send requests, and receive information from other information systems and databases. We also created integration with other information systems from other government agents, and one of the examples of such successful integration is the exchange of information with the State Migration Service. This way, a notary receives information or personal data from an individual to ensure security. That process was introduced already. Currently, we are introducing certain functions in the system so that users can verify the authenticity of notarial acts for using dedicated codes. Using a QR code, for example, this is a dedicated feature to verify a notarial act, and the QR codes will be part of the notary's work. And these are not experiments, but our continuous regular products that have already been adopted after the government's decision in 2023. Notaries can make proposals to the government as to the further digitization of notarial services. Given the full-scale invasion of Russia into Ukraine and the continued aggression, not all of the work that we have planned we were able to perform and achieve. I would like to emphasize that the digitization of notary archives during the war plays an important role in ensuring the preservation and accessibility of critical information. And the main aspects of its impact are preservation of documents. So military operations often lead to the physical destruction of archives containing important legal documents, such as inheritance files, contracts, wills. So transferring these documents into digital form will protect them from loss or damage. For example, almost 200 tons of notarial documents were evacuated from the area of active hostilities. And these documents are currently being sorted, organized, and in the process of digitization. Accessibility, digital archives provide quick access to documents, even during evacuation or displacement. This facilitates the recovery of documents necessary for resolving legal disputes, regardless of the physical location of the person. This system will provide business continuity. Even in difficult conditions of war, notaries will be able to continue to work and perform notarial acts. Using digital archives and secure electronic platforms, this will contribute to the maintenance of the legal order and respect for the rights of citizens. The e-system will improve security. Digitization allows the use of modern methods of encryption and data protection, which reduces the risk of unauthorized access to confidential information. In wartime, this is especially important to prevent illegal manipulation of documents. Digitization will facilitate document recovery. After the war, digital archives can be used to recover lost documents and resolve legal conflicts. So digitalization of notary archives is an important tool for protecting the rights of citizens and preserving legal heritage during the war. Therefore, international experience and expert support in regulating the notary sector is very important for us to create an effective, transparent, and reliable legal system. Thank you for your comprehensive support and assistance. Thank you very much.
Dėkojam už pranešimą. Kviečiu
Thank you for this presentation. And now I would like to invite to the stage Associate Professor Dr. Victoria Barankova, Professor at the Department of Civil Justice and Advocacy of the Yaroslav Mudry National University, to give a presentation.
Колеги, і вибачте мені, будь ласка, моє зайве хвилювання.
Thank you. And I welcome you. I am very sorry for being emotional. I am more than happy today, and I can prove myself that you can be happy even at the time of war. Whenever I attend international events, I thank the organizers because they provide the opportunity to share the things we have achieved in the number of years. And it is the result of a huge work. We can also exchange our experiences and understand each other better. In this case, I would like to thank not only for the organization of this conference, but also for this warmth you demonstrate to the Ukrainian delegation. We feel very special. We feel very wanted and provided with everything, and it hardly compares to anything. And I would also like to thank each and every of you for being alive and be able to live in Kharkiv, which is only 35 kilometers away from the aggressor. And that's why the rockets and shells can be thrown by hand to Kharkiv. In Kharkiv, we don't react to these air shelling alarm because, first of all, you hear the explosion and then the alarm is switched on. And my city is being bombed. And yesterday I looked at your beautiful city When I was sightseeing in your beautiful city, there were 2 bombardments in Kharkiv, and lives were taken away, and someone's houses and home were destroyed. And I would like to say that to each of you that these words of support are not abstract. I want you to understand that the price of this support is the people's lives and preservation of people's lives. I can stand today in front of you and continue my work because of our heroes and your support. I'm here because each of you, irrespective of the form, it doesn't matter at all. The form of support doesn't matter. So each of you help Ukraine a lot, and Ukraine knows that it is not alone. And each of you show this openly. And now I will switch to today's topic about the Ukrainian Notariat, because the Ukrainian Notariat, like the Notariat of any other country, appeared when the country understood one simple rule. When we understood that it's better to prevent a disease than to get ill with it, and the Ukrainian Notariat serves in order to prevent the violation of the human rights. In order to resolve the dispute without the court, so the notaries come into play. So the Ukrainian Notariat is a part of the Latin Notariat due to 2 reasons. The first one is the Ukrainian legal system. According to this legal system, notarized documents have a special status in our country, and we can say that Ukrainian Notariat is very special because we have private notaries in our legal system. Why I'm saying private? Because the notaries in Ukraine were the first representatives of the free and independent legal profession in Ukraine. Today, we have other liberal professions in Ukraine as well, not only notaries, but namely notaries have a very interesting history. If we speak about the Ukrainian Notariat as the Latin Notariat, we can say that the Ukrainian Notariat plays a preventive function. And this concept has been developing for a number of years. I've been working as a notary very long, and The concept of preventive law caused some objections in the Ukrainian society. According to the Ukrainian constitution, no institution can perform the functions of the court. Therefore, society was misled when they heard this concept for the first time, because it was thought that notaries will take over the function of the courts, and it took us long to prove that we don't mean it. And in the previous presentation, we heard that it is the extension of the court's functions in the other form, and it does not mean taking this function away from the courts. I will tell you briefly how in Ukraine the workload for courts is reduced by notaries. And you probably heard the saying that the notariat is sad and it avoids funny quotes. My students find hard to understand why the notariat is sad. The notarial procedures in Ukraine are very serious and very clearly defined. Unfortunately, there is one shortback, that the notaries are not regulated by law. They are in great difficulties today because their activities can't be questioned in court, and the notarial procedures are established by the order of the Minister of Justice rather than the legislation. And it's a great drawback, and we have to eliminate it. Now I'd like to come back to the issue of reducing the load of courts by the notaries. I will come back to that, but before I would like to specify another special characteristic of notaries' activities in Ukraine. In 2022, Kharkiv, since the beginning of full-scale invasion, was left by a number of people. Later on, the Ukrainian armed forces allowed us to come back to our home, to our normal life, and we already had 3 waves of people returning to Kharkiv. And the first wave was notaries, because notaries feel responsibility. Ukrainian notaries is the strongest legal profession there, and it is the legal profession which has the greatest legal experience, because the judicial system is divided into different specializations according to our constitution. It's good and it's very convenient. When the jurisdiction is also divided, we have different codes, different rules according to which the cases are being resolved. And each court specializes in different areas, for example, civil or criminal cases. The same can be said about the profession of lawyers. Few people would go to the lawyer for legal assistance. I mean the lawyer who is engaged in both civil and criminal cases, because This happened because of the lack of confidence, because our lawyers also try to specialize. They either work with civil cases or only with criminal cases.
Спеціалізується на тих чи інших судових справах. А от нотаріусу це дозволити собі не можна.
Whereas the notary cannot afford this. They have such a workload that they gain experience in a number of areas which is not possible to other legal profession. And now I would like to come back to the reducing of the workload of courts. The first and the most simple way is ensuring stability and non-violation of laws. According to Ukrainian legislation, we have a very specific institute in the notarial procedures as the involvement of the interested parties which do not contact the notary but whose rights may be affected in this notarial action. And this allows the notary to understand such a person's will, and in this way the legal case is not initiated because the notary learns and explains the will of a certain party. The workload is also reduced in the following way. We have two notarial acts which are carried out in order to ensure security, and the Ukrainian constitution is not violated because the notary impartially establishes the level of a debt, the level of the debt which is established in the legislation. So the notary operates only in the area where no disputes may arise. And the third way is a bit concealed, hidden from the general public, meaning a non-professional party. Any notarial stamp, irrespective of its beauty, or irrespective of the professionalism of the notary, is important. I am a scholar as well, and I can say that it's a very important profession, but notaries cannot protect people in every situation and avoid disputes in every situation, irrespective of the beauty of the notary's steel. It does not prevent from failure to comply with the party's obligations, and this results in a legal case. But this is not the fault of the notary or the drawbacks of the legislation. When the dispute arises, the notary's activities carried out before that facilitate the case at court, the resolution of the case at court, because the judge will not have to make so much effort, and some things will be evidenced and justified by notarial acts. Unfortunately, my time is nearly up. I could tell a lot of other interesting things, how all these matters are governed in Ukraine, but that's okay. You were listening very attentively to my presentation. I thank you very much for your attention. Thank you very much for your presentation. According to our agenda, we have a coffee break now, and I would like to invite everyone to come back here at 11 sharp.